entire back firmly against the wood, and shut my eyes tight. In my left hand, I was tightly clutching a fresh home mortgage receipt from that morning's mail. $1,847. I had personally authorized that payment. Identical to every single month prior. I was absolutely not renting a single piece of my existence. I hand-built it. Every single mortgage transaction, every late-night legal filing, every single morning I woke up right next to his sleeping frame and consciously chose the shared life. It was mine. It had always been mine. Dale behaved with far more stealth than the emotional women. He completely avoided direct confrontations. Instead, he systematically maneuvered through asset blockades. The very first structural interference I identified involved the heavy padlock. Grant maintained a commercial storage building positioned directly behind our residence. It was a basic structure of corrugated sheet metal, completely lacking insulation, but packed to the ceiling with his historical commercial operations records, old corporate invoices, and a heavy metal filing cabinet containing duplicates of every single legal contract his business had ever signed. I stepped out to the backyard one morning to extract some past municipal permits and discovered a brand new, heavy-duty combination lock completely securing the door latch. I had absolutely no part in placing it there. I immediately dialed Dale's private number. He answered the line on the fourth continuous ring. "Oh, yeah, that. I personally secured that structure as part of my official estate management duties," he stated with an incredibly casual tone, as if he were explaining a routine tire change. As the legally designated executor, I possess a strict fiduciary responsibility to safeguard all corporate estate assets. Fiduciary responsibility. Dale was currently operating a commercial construction firm that was actively hemorrhaging capital into the red. He had completely defaulted on 2 major commercial contracts during the previous calendar year and was months behind on standard payments to his independent subcontractors. That was the bankrupt individual attempting to lecture me regarding high fiduciary obligations. A mere 7 days later, I uncovered a second maneuver. He had drafted and dispatched a formal corporate demand letter to our banking institution. He utilized custom company letterhead that he must have personally had printed for this specific scam, explicitly identifying his person as the absolute executor of the estate and demanding an immediate legal hold be placed on Grant's commercial plumbing sole proprietorship account. The banking staff complied without checking further. Then I reviewed our private joint savings profile. Completely frozen. I immediately placed a call to the bank headquarters, demanded to speak directly with the branch director named Linda, and directly cited Virginia Code Section 64.238. A joint tenancy holding operating with an explicit right of survivorship constitutes a non-probate asset by law. It automatically and instantly transfers ownership to the remaining living co-owner. Linda responded defensively, "Ma'am, our institution received a formal legal directive from the estate's designated executor. We are legally required to verify the authenticity. The account registry is explicitly titled as joint with right of survivorship," I stated with absolute professional authority. "It bypasses the probate process entirely. The designated executor commands absolutely zero legal jurisdiction over those funds." Linda reluctantly promised a comprehensive internal review within 5 business days. I meticulously documented her first and last name, the exact calendar date, the precise time, and the specific tracking reference number she provided. The heavy master folder was becoming an immense physical burden to carry. Exactly 5 days later, my phone rang. It was Linda, the exact same branch manager. Her vocal delivery was noticeably warmer and significantly more deferential this time around. "Ms. Myers, our legal department has thoroughly reviewed the account architecture. You are entirely correct. The joint funds transfer exclusively to you as the surviving co-owner. The administrative hold has been completely dissolved." I immediately executed an electronic wire transfer to fully fund Dr. Sears's professional expert retainer that identical afternoon. $3,200 vanished from the exact asset pool my husband and I had built hand in hand over 7 years of continuous direct deposits and strict financial discipline. However, while I was meticulously auditing the transaction history, I stumbled upon a devastating anomaly. A clean financial withdrawal of exactly $2,800 had been executed from Grant's commercial sole proprietorship account, his private business registry, held exclusively in his individual name. The transaction was dated exactly 3 weeks following his physical passing. The formal authorization letter preserved in the bank records carried Dale's signature right next to the word executor. The legal flaw in his maneuver was beautifully simple. The fraudulent will naming Dale as the executor had absolutely not been validated or confirmed by a judge yet. He possessed zero legal authority to access or drain that account. I printed out the digital statement, utilized a bright highlighter to mark the illegal transaction, and secured it under a brand new divider tab inside the expanding master file. That identical evening, I carefully packaged 6 of Grant's cleanest, most pristine signatures extracted from historical federal tax returns, our home purchase deed, and a commercial invoice from a comprehensive kitchen structural remodel he had executed over in Pennsylvania, and dispatched them straight to Dr. Sears utilizing priority overnight delivery. Then I sat down heavily on the absolute perimeter of our bed. The entire house was completely black except for the faint glow emanating from the corridor light fixture. On the ceramic bathroom shelf, Grant's glass bottle of Old Spice cologne rested precisely where his hand had left it, half full, the plastic cap sitting crooked because he simply never took the time to screw it on tight. I picked up the container, held the opening directly against my face, and shut my eyes tight. The familiar aroma was beginning to disappear. Absolutely everything in my world was slowly fading away, with the sole exception of the legal case. The case was becoming sharper and more lethal with each passing day. You are likely familiar with that highly specific psychological sensation, the moment an arrogant individual assures you that you are entirely powerless, while every single fiber of your physical being knows with absolute certainty that they are completely wrong. That exact mindset fueled my spirit every single morning when I navigated the drive to my office with that expanding folder resting on the passenger seat. If you have ever been forced to mathematically validate your own worth to narcissistic people who had already concluded that your existence didn't matter, I need you to stay locked into this video. The exact moment of retribution you have been waiting for is about to unfold. Exactly 6 weeks after the physical samples were delivered, Dr. Sears contacted my line. "I have officially formulated my preliminary investigative findings," she stated. "Can you visit my laboratory immediately?" Her corporate facility was located deep within an industrial complex right off Route 1, a minimalist brick structure featuring a small identification plaque beside the entryway that read Sears Forensic Document Services. The interior space appeared to be an exact hybrid between a sterile dental clinic and a high-tech state crime laboratory. It was packed with heavy magnification apparatus, specialized ultraviolet light boxes, and a massive digital scanning unit the size of a commercial refrigerator. She instructed me to sit directly across from her desk and laid open a heavy binder filled with protective plastic sleeves. Each individual sleeve preserved a massive, high-resolution digital enlargement of Grant's signature. "The cursive signature affixed to the contested legal document is completely inconsistent with the verified exemplars," she stated firmly. She pointed her pen directly toward the massive enlargements. "Focus your attention right here. The mechanical pen pressure applied across the center strokes is entirely too uniform. Within an authentic human signature, fluid pressure naturally fluctuates constantly. The line is inherently lighter on upward strokes, and significantly heavier on downward strokes. This specific signature maintains a completely identical pressure across the entire sequence, which is a classic diagnostic hallmark of deliberate tracing." She flipped the page to a transparent digital overlay. The fraudulent signature was layered directly over a verified authentic one, perfectly adjusted for spatial scale. The alignment slant angle deviates by approximately 12 full degrees from every single authentic exemplar in our possession. And right here, she adjusted her finger toward the absolute base of the uppercase letter G, there are distinct microscopic graphite remnants trapped directly beneath the layer of ink. An individual explicitly sketched the outline of the signature utilizing a graphite pencil first, and subsequently traced over the pencil line with a standard ink pen. She closed the heavy binder with a firm thud. In my professional evaluation, this specific signature was absolutely not executed by the identical human hand that produced the baseline exemplars. I asked her the exact number of times she had delivered expert testimony inside a court of law. 47 times, she replied without hesitation. The formal, finalized report would require 2 additional weeks to generate. I held those preliminary forensic findings tightly on my lap during the drive home, feeling the physical center of gravity shifting in my world. Nancy's hired legal counsel initiated their opening tactical move in early January. His name was Richard Hartwell. He was in his mid-50s, operating a small private practice out of a modest office down in Woodbridge, primarily handling basic residential real estate transactions and minor traffic citations. Complex estate litigation was absolutely not his professional specialty, a reality that signaled to me Nancy had selected his services strictly because he was inexpensive, or perhaps a close personal friend, or potentially both. Hartwell dispatched a formal letter to my residence offering an administrative settlement. The proposed terms were laughable. I would be allowed to retain Grant's immediate personal belongings and receive a one-time cash payment of exactly $15,000. In exchange, Nancy would secure absolute ownership of our residential home, the entire shared savings account, and the massive life insurance payout. $15,000. Our shared savings account alone contained exactly $63,000 in liquid cash. The residential property was valued at $225,000 based on the extensive equity we had built together through years of continuous payments. The life insurance policy was valued at exactly $200,000. They were offering me absolute pocket change to willingly walk away from every single asset my husband and I had hand-built over 7 years of shared dedication. I formulated my official response via corporate email, incredibly brief, completely professional, and formally copied directly to the official court record file. The respondent explicitly rejects the proposed settlement offer in its entirety and maintains full intent to proceed with the will contest as formally filed with the court. That identical night, Paige dialed my phone at exactly 10 p.m. Her vocal delivery strongly indicated she had been consuming alcohol. "You are going to completely lose every single asset you have and make yourself look absolutely ridiculous in front of the entire community while doing it," she snarled. "Have a pleasant evening, Paige," I replied coldly, and instantly terminated the connection. The subsequent morning, Dale attempted a different psychological approach. His voice radiated that classic, patronizing Uncle Knows Best emotional warmth, the exact variety of false sincerity that Grant used to routinely roll his eyes at. "Ingrid, this situation absolutely does not require a messy courtroom battle. Licensed attorneys are incredibly expensive. Take some time to truly think about the long-term consequences here." "I do not possess a licensed attorney, Dale. I am representing my own interests in court." The phone line went completely dead for several moments. Finally, he murmured, "That is entirely your choice," and hung up the phone. I understood with absolute cognitive clarity exactly what their desperate settlement offer indicated. It meant they were completely terrified. A forged legal document can only maintain its false validity as long as absolutely nobody subjects the paper to microscopic expert scrutiny. They were desperately praying that I would lack the professional knowledge to look closer. They were entirely counting on me being completely isolated, emotionally overwhelmed, and too paralyzed by sorrow to mount a defense. They were completely incorrect on every single calculation. Dr. Sears's finalized forensic report arrived at my home during the first week of February, a massive 22-page document fortified by 6 extensive technical appendices composed entirely of high-magnification photographic evidence. I reviewed the findings while sitting in my primary living room with Grant's leather briefcase resting fully open on the coffee table, the dim late-afternoon winter light filtering through the window pane where Grant's dogwood tree stood completely bare against the cold. The absolute definitive conclusion was positioned clearly on page 4. The questioned signature affixed to the legal document dated August 3 does not represent an authentic, genuine signature executed by the purported testator, Grant Allen Myers. The signature was unequivocally manufactured through a mechanical process of manual tracing, heavily verified by the following diagnostic indicators. 1. Distinct subsurface graphite deposits perfectly consistent with a preliminary pencil sketch. 2. Entirely uniform ink pen pressure completely inconsistent with natural human handwriting dynamics. 3. A highly significant 12-degree alignment slant deviation from all 6 verified baseline exemplars. 4. A completely reversed stroke. Execution direction within the uppercase letter G, directly contradicting the testator's deeply established, unvarying habitual pattern. The extensive technical appendices featured side-by-side microscopic digital enlargements at 400% magnification, advanced electronic pressure mapping algorithms, and comprehensive spatial overlay comparisons that rendered the amateur forgery almost comically transparent once an individual possessed the exact knowledge of where to look. I carefully slid the final forensic document into the absolute last tab divider of the leather briefcase. Every single section was entirely filled now, 7 comprehensive tabs, every solitary piece of evidence meticulously indexed, cross-referenced, and perfectly arranged to be presented in the exact logical sequence I had repeatedly rehearsed in my mind. I gazed out the window pane. The flowering dogwood tree had not produced a single bud yet, but the exterior branches appeared noticeably darker and richer than they had during the bleak weeks of December. The natural sap was rising, life was forcefully migrating upward through wood that appeared completely dead to an outside observer. Our official trial date was exactly 3 weeks away. I had already formulated every single line of my judicial opening statement. I had already officially scheduled the appearances of my primary witnesses. I had already formally submitted my master exhibit registry to the clerk of the court, which included delivering a complete duplicate of Dr. Sears's finalized report to the opposition's legal counsel exactly 10 days prior to the trial, precisely mirroring the strict rules of discovery. I was completely prepared, and the absolute solitary human being who comprehended the sheer magnitude of that preparation was me. I spent the subsequent 3 weeks executing trial preparation in the exact meticulous manner I visualize elite surgeons preparing for a complex operation, obsessively, systematically, mapping out every single conceivable procedural complication and engineering a flawless response for each individual scenario. I drafted and redrafted my opening statement repeatedly until I could articulate the entire speech directly from cognitive memory without glancing at a page. I neatly organized the sequence of my witnesses. Dr. Sears would take the stand first to establish an unshakable forensic foundation. Tommy would follow second to formally authenticate our original last will and testament. Margaret's legalized affidavit would be formally submitted as core documentary evidence. I practiced my delivery continuously in front of my bathroom mirror, then transitioned to practicing directly in front of my living room sofa, and ultimately executed mock trials over Zoom with Margaret, who sat inside her private home office and evaluated my performance with the stern demeanor of an active judge. Decelerate your pacing significantly during the forensic technical analysis section, she coached firmly. Allow the weight of the evidence to truly breathe in the room. Do not rush through the details. When you establish the absolute visual overlay, ensure you make direct eye contact with the judge. I adjusted my delivery precisely according to her commands. By the time the final evening before the trial arrived, I felt completely calm. It was not the artificial calm born of raw emotional denial, it was the exact, unyielding composure that arrives when you have left absolutely nothing to chance. The morning of the trial, the conditions inside the Stafford County Courthouse were precisely as I have detailed. The heavy walnut tables, the clinical lighting, the aggressive arrogance vibrating across the aisle from Hartwell and his clients. Presiding Judge Evelyn Okafor entered the room precisely at 9 a.m., her black judicial robes flowing seamlessly behind her frame as she assumed her position at the bench. She formally called our active case registry. Hartwell stood up from his chair first. His opening presentation was incredibly polished and smooth. Your Honor, the decedent Grant Allen Myers fully executed a completely valid last will and testament exactly 2 months prior to his untimely passing, properly authenticated by signatures and fully witnessed by third parties. The decedent's surviving widow is launching this legal contest strictly out of intense emotional grief and psychological confusion, which, while entirely understandable from a human perspective, absolutely does not constitute valid legal grounds to invalidate a properly executed and filed testamentary instrument. We respectfully request this court to uphold the will exactly as filed. Grief and confusion. I allowed that offensive characterization to hang in the silent room for several moments. Then I stood up tall. Your Honor, I am absolutely not confused. I operate professionally as a senior paralegal with 7 full years of active experience specializing in estate planning and administration at a law firm that routinely handles complex probate litigation. The testamentary document submitted to this court by the petitioner is an absolute, undeniable forgery, and I possess the comprehensive forensic evidence required to prove that reality to this court. The entire room instantly became noticeably quieter. Hartwell's ink pen completely stopped moving across his notepad. Nancy shifted her posture, sitting up significantly straighter in her chair. Right before the presiding judge offered a verbal response, my eyes captured a highly specific nuance. A tiny, completely private emotional moment. Nancy had quietly opened her leather wallet directly in her lap under the table line. Resting inside the plastic window was an old photograph. It depicted Grant as a young boy, perhaps 8 years old, proudly holding a freshly caught fish while standing on a wooden dock somewhere. Nancy's thumb was resting gently on the frayed perimeter of the image. Her eyes were visibly swimming with genuine moisture. She snapped the wallet shut instantly the exact millisecond she felt my eyes tracking her movements. Her maternal sorrow was completely authentic, but that emotional reality did not possess the ethical power to justify the absolute crime she had executed against her son's legacy. I initiated my presentation utilizing the financial documentation. Your Honor, I would like to formally introduce Exhibit A into evidence. I handed authenticated duplicates directly to the judicial clerk, passed copies to Hartwell, and preserved 1 reference sheet for my own use. 7 comprehensive years of historical home mortgage statements, documenting every single monthly payment of exactly $1,847 extracted directly from our joint checking account. Next came Exhibit B, comprehensive utility bills, residential insurance policies, and municipal tax declarations spanning our entire marital union. I systematically proved that the financial foundation of that home was hand-built step by step through our joint dedication. I formally called Tommy Hale to step up to the witness stand. He was dressed in a crisp button-down shirt tucked neatly into pristine blue jeans, the absolute most formal attire I had ever witnessed him wearing in our entire history, and I could instantly tell the stiff fabric collar was causing him immense discomfort by the way he repeatedly inserted a finger to stretch the seam away from his neck. He raised his right hand high, swore a solemn oath to articulate the absolute truth, and sat down inside the wooden witness box with the ultra-careful, rigid posture of an honest man who deeply respects the gravity of a court of law but passionately desired to be absolutely anywhere else on earth. Mr. Hale, I initiated calmly, did you personally witness Grant Allen Myers execute a last will and testament approximately 4 years ago? Yes, ma'am, I absolutely did. It took place directly within the corporate offices of Jenkins and Whitmore located over on Princess Anne Street. Grant personally requested that I visit the facility. We sat down together around a large conference table. He signed the will document. I immediately affixed my own signature as an official witness. Mrs. Whitmore subsequently signed the document as our second legal witness. Did you ever witness Grant sign any other last will and testament at any other chronological point in his life? No, absolutely never. Are you personally familiar with either of the individual names listed as executing witnesses on the document currently submitted to this court by the petitioner? He focused his eyes completely on the fraudulent paperwork I handed to his box, then slowly shook his head side to side. I have absolutely never heard of either one of those individuals in my entire life. And Grant and I communicated with each other every couple of weeks without fail. He would have absolutely mentioned something as monumental as executing a brand new last will. Hartwell stood up to execute his cross-examination. Mr. Hale, how would you characterize the exact nature of your personal relationship to the respondent in this matter? Tommy stared directly back at him with an unyielding look. I was incredibly close to Grant. And Grant trusted Ingrid with absolutely every single asset he owned on this earth. That reality is more than good enough for me. I formally presented Exhibit D to the bench. The authentic, original will retrieved directly from the reinforced safety deposit box. It bore Grant's signature, the genuine, authentic script featuring that beautiful counterclockwise loop on the letter G that I could have easily replicated from memory. It bore Tommy's authentic name. It bore Margaret Whitmore's professional signature. Leaving absolutely everything to each other. Judge Okafor held both wills simultaneously side by side, balancing one document in her left hand and the opposing paper in her right hand, studying the handwriting features intensely without displaying a single flicker of facial expression. My mind immediately flashed back to the venomous statement Paige had spat at me. Blood is blood, sweetheart. You were just renting the name. Grant had fundamentally disagreed with that concept. Grant had permanently captured his true answer in written ink. Your Honor, I would like to formally call my absolute final witness to the stand. I paused my speech intentionally, allowing the gravity of the sentence to fully settle into the room. Dr. Ellen Sears, Certified Forensic Document Examiner. Hartwell attempted to launch an immediate procedural objection regarding the witness disclosure timeline, but Judge Okafor brushed his defense aside instantly with a sharp wave of her hand. The expert report was properly delivered to your office exactly 10 days ago, Mr. Hartwell. The discovery protocol has been perfectly satisfied. Objection overruled. Dr. Sears, please take the stand. What transpired over the subsequent 45 minutes was the absolute and complete systematic destruction of their entire scam. Dr. Sears projected her advanced digital overlays onto the courtroom's electronic screens. She meticulously explained the uniform pen pressure dynamics, pointing out the microscopic pencil graphite fragments trapped directly beneath the ink line under 400% magnification. She demonstrated the 12-degree alignment slant angle deviation and highlighted the entirely reversed stroke dynamics used to trace the capital letter G. She dismantled the amateur forgery with the clinical, unbothered precision of an elite mechanism processing structural data. By the time she finished her expert testimony, the paper they had pinned their entire asset seizure on was reduced to absolute garbage. I formally introduced Exhibit F into evidence, Grant's authentic, verified digital business calendar, confirming with total tracking accuracy that he was located 180 miles away down in Roanoke doing heavy excavator work during the exact calendar week they claimed he was signing that paper at a dining room table in Stafford. Presiding Judge Okafor evaluated the digital calendar printout, transitioned her gaze to the contested fraudulent will, and ultimately locked her eyes directly onto Nancy. The leather briefcase resting on my counsel table was completely empty now. Every single piece of evidence was laid out across the judge's bench. 7 comprehensive tabs of devastating documentary proof spread wide across the dark wood. The single manila folder I had initiated building during the cold nights of October. The identical folder that had accompanied me on the passenger seat of my car every single morning for 5 continuous months. The file that expanded from a few basic pages to an inch, then to 2 full inches, transforming into a physical mass that I could deeply feel in my shoulder muscles whenever I carried the case. It had executed its purpose perfectly. Nancy's fingers were tightly locked together on the table surface, her knuckles completely white from pressure. Paige had completely ceased touching her smartphone. She sat entirely rigid in the gallery bench, staring directly ahead at the wall blankly. Dale kept his eyes locked entirely on the floor. Judge Okafor turned her head directly toward Nancy. Mrs. Caldwell, do you desire to offer formal testimony to this court regarding the true origin of this document? Nancy stood up from her chair. She smoothed the fabric of her dark blazer. She initiated her speech utilizing a vocal delivery that was almost entirely composed, the unmistakable voice of an aging woman who had spent 61 years keeping her physical frame upright through horrific hardships. That will represented Grant's absolute final emotional wish, she stated defensively. He communicated the reality to me himself. He explicitly stated that he desired for his biological mother to be fully taken care of. He articulated that desire more than once. I waited for her to finish speaking. Then I spoke with a calm, clinical, professional delivery. The identical vocal tone I deploy whenever I cite complex statutory case law for clients who are on the precipice of losing absolutely everything and desperately require a legal explanation as to why. Your Honor, if the petitioner asserts that the decedent communicated his testamentary desires through verbal statements, I would respectfully direct the court's attention to Virginia Code Section 64.2/4003, which strictly dictates that a last will and testament must be executed in writing and signed by the testator. Oral declarations are entirely inadmissible to establish or alter testamentary intent within this legal jurisdiction. Nancy's artificial composure completely shattered. Not in a gradual manner. All at once, precisely like a glass windshield experiencing the impact of a high-velocity rock. "She is lying," she screamed at the bench. She pointed her arm fully across the aisle toward my face, her limb fully extended, her index finger shaking violently. "That asset is my son's house. I raised that boy completely alone for 23 years. I sacrificed absolutely everything I possessed. My personal career, my marriage, my entire life, just so he could possess something of real value. And this woman walks inside this courtroom after a mere 7 years and attempts to seize absolutely everything." Judge Okafor grasped her heavy wooden gavel, striking the sound block a single time with immense force. "Mrs. Caldwell, sit down immediately." Nancy sank back into her seat. She was trembling violently. Paige stood up abruptly in the gallery row, took one step toward the center aisle, then completely froze, trapped between the impulse to fight and the urge to flee. She chose immediate flight. I listened to the heavy acoustic sound of the courtroom exit door swinging shut behind her frame. I did not utter another word. I didn't need to. I stood completely still at my table, my palms resting gently on the wooden edge, and waited patiently for the judge to deliver the final ruling. Judge Okafor thoroughly reviewed her trial notes. She looked intensely at the two wills, one resting on her left side, one positioned on her right side. She evaluated Dr. Sears's forensic report. She scanned the digital calendar printout. She slowly removed her reading glasses and positioned them gently on the wooden bench. The entire courtroom was completely silent, with the sole exception of the court reporter's shorthand machine, which had ceased operating because absolutely nobody was speaking a word. 30 seconds passed by. Perhaps 40 seconds. The absolute longest duration of silence in my entire life. The court finds by clear and convincing evidence that the cursive signature affixed to the document submitted to this court by the petitioner is an absolute fraud. One single sentence. That was the absolute only requirement. She continued her decree. The will filed by Nancy Caldwell on behalf of the estate of Grant Allen Myers is hereby officially declared null and void. The court formally recognizes the validity of the prior will executed approximately 4 years before the decedent's passing, properly witnessed and authenticated by 2 highly credible witnesses. Under that legally binding instrument, the decedent's entire estate transfers in its absolute entirety to his surviving spouse, Ingrid Myers. She paused her speech for a moment. Additionally, this court is formally referring the entirety of this matter regarding the fraudulent document directly to the Stafford County Commonwealth's attorney for the immediate initiation of a comprehensive criminal forgery and estate fraud investigation. This session is now adjourned. She struck her gavel down. The sound hit the room like a lightning bolt. Hartwell began packing his documents in absolute silence, completely refusing to look at Nancy, who sat entirely motionless like a stone statue in her chair. Dale had already vanished through the rear exit without saying a single word to his sister. I closed my premium leather bag. It carried the exact same physical elements it had when I arrived that morning, but it felt entirely weightless in my hand as I walked back down the aisle. The heavy interior of my vehicle remained secured. Inside the leather interior was that single piece of lined notebook paper extracted from the bank vault, his authentic handwriting, his unshakable trust. I absolutely did not rent a single piece of my existence. I hand-built it. Every single mortgage transaction, every late-night legal filing, every single morning I woke up right next to his sleeping frame and consciously chose the shared life. It was mine. It had always been mine. Maintaining total silence does not indicate that you have willingly accepted defeat. Sometimes it simply indicates that you are meticulously constructing a legal case so incredibly solid that when you ultimately choose to speak, the only physical sound remaining in the room is the exact sound of the opposition's arrogant confidence hitting the floor. That encompasses my entire story. Half a year of absolute silence, one single master folder, and a presiding judge who required only one sentence to deliver justice. If this narrative served to remind your soul that meticulous preparation is its own unique manifestation of lethal power, share this video immediately with someone who desperately needs to hear that truth today. And if you have ever been forced to stand completely alone in a room packed with toxic people who had already counted you out of the fight, I would absolutely love to hear your personal journey. Drop a comprehensive comment down below, hit that subscribe button, and I will see you layout in the next video.